call Nigel Don to be followed by Cathy Craigie.
Thank you very much, Deputy Presiding Officer. As usual, Presiding Officer, I would not want to spend too much time repeating what colleagues have already said. Instead, I would like to look at one or two issues and maybe offer a few helpful comments. The first thing I would like to do is to go right back to the very beginning of this and point members in the direction of Section 1 of the Bill, which sets out the regulatory objectives, which I shall repeat. They are supporting the constitutional principle of the rule of law. They are protecting and promoting the interests of consumers and the public interest generally. They are promoting access to justice and competition in the provision of legal services, promoting an independent, strong, varied and effective legal service, encouraging equal opportunities, and promoting and maintaining adherence to professional principles. Now, I take us back to those simply to make the point that that is the intention of the law. And some of the comments that have been made, and they have already been referred to, have tended to suggest that the law might be the bill might be here to undermine those. It's very clear at the beginning that it is not the intention to undermine those. And we have to make sure that in its outworking it does stick to its original principles. I'm conscious that there is concern about ethical principles. Section 2, which I won't quote, actually expands on those. And I think it was very clear that the Minister, in evidence to the committee, felt that nobody involved in any of the alternative business services should be subject to any lower ethical standard than lawyers are at the present. Now, if it's brief, yes, please.
Thank you very much.
Robert Brown.
On the question of ethics, would Nigel Dunn accept that writing it all down in the bill is one thing, imbuing it right through the legal profession is something else again?
Well, I think I take your point, although, of course, I would also take the point that those who have trained as lawyers have it, in exactly the same way that those who trained as medics, to come back to David McClutch's point, have it. It's part of what you do, in exactly the same way that I might say in my own profession of chemical engineering, safety is your middle name. But it doesn't alter the fact that we should make sure that those ethical standards are somewhere within the text. It doesn't matter where. There is an argument that the privilege which is accorded in Section 60 assumes those kind of ethical standards, but it might be worth making sure that we write them down. Another issue that I'd like to address is how we might allow businesses to describe themselves. And this is something which has been brought up, but on which I don't think there's yet been any comment, and I would like to make it. It has, in some people's minds, been described as branding, and I have to say that I think that is an error. If one were to turn one's mind to the idea of a can of soup, which will be helpful, I hope, then the brand would be the Heinz or the Campbells or the Baxters on the label. They will all make tomato soup. They also make minestrone soup or mushroom soup or any other. The descriptor is the tomato, minestrone or mushroom. The brand is the Heinz, Campbell's or Baxter's. Now, reserved descriptions are something that we actually know in the law of food. Once upon a time, we used to buy margarine. We no longer buy very much margarine because very little is sold as margarine, because margarine it is a reserved description to have 80% fat. And I think what we're looking for in these legal service providers is what I would describe, therefore, as reserved descriptions, so that the customer, a potential client, knows what they're going to get by the way the business is described. Its branding will be its commercial name, but its descriptor ought to say what we've got. Now, with that in mind, Deputy Presiding Officer, it seems to me that there are some possibilities. I put these forward, as members will understand, not because I think they are the right answer, but because they might be a way of bringing the debate forward and seeing whether we can get some sensible words. I would like to suggest that it is at least possible that if some future firm was, for example, composed of 60% solicitors and 40% accountants, it might be reasonable to describe them as solicitors and accountants. If the numbers were the other way round, they should, I think, be accountants and solicitors. Clearly, if it happened to be 50-50, we'd have to find a way of resolving that. It doesn't really matter. They would also, I think, have to say underneath, and in not too small letters, that they are a regulated legal services provider, so we're very clear that they are under the umbrella of the law that we're talking about. Now, I put it forward as simply as a suggestion for further comment, that if the split was not 60-40, but actually the number of solicitors was, say, greater than 80%, and the number of accountants or others was, say, less than 20%, that these might be solicitors with accountants, but also, of course, the subscript about being a regulated legal services provider. Now, I think we are going to have to come to some kind of table of that kind, and I put those forward merely as some thoughts in the hope that other people can improve on them. The other point in connection with that, Presiding Officer, is it does seem to me that it ought not to be necessary for solicitors to be 100% solicitors in order to describe themselves as such. Maybe if they were at least 90% solicitors, that would actually be enough. Let me push on very quickly, as time is, as always, against me. I'd like to make, one of the points that I'd like to make is that there has been some suggestion, and I think it carries on, that advocates should be able to be involved in alternative business structures. And I think the point is worth putting on record that we do not have actually very many practicing advocates. They are supposed to obey the cap rank rule, to which I will return very briefly. And if they were allowed to be involved in alternative business structures, then actually the number who would not have a conflict of interest would be reduced. And that seems to me to be very clearly not in the interest of competition. And I would just also observe that the Thompson Review at page 58, paragraph 10, does quote an authority as suggesting that the cab rank rule is a polite fiction. And I think that is an issue which the faculty might choose to address, because I think there is a perception that the system does not work quite as well as it should. Can I endorse the view of Richard Baker? I think we have to take this bill in principle, we have to push it forward, we have to see if we can improve it, and I'm pretty sure that we can. I take Robert Brown's comments about the effects of unrestricted competition. I think we need to be aware of those as well. I don't think voting this down at this stage is in any way the right thing to do. We need to take it forward today and then see if we can improve it as we go along in the light of the many comments we have received. Thank you.